Sir, let me see your ID.
What?
Identification, now.
I'm just getting coffee like everyone else here.
Step outside with me.
What? I'm not doing anything.
Turn around.
Hey, easy. What are you doing?
The security camera footage from Martin's Coffee House in downtown Chicago starts at 7:27 a.m. on a Wednesday morning in October. Interior of the shop, typical morning rush. Maybe 15 people in line or waiting for orders. Near the register, there's a black man in his mid-50s wearing a suit under an overcoat, looking at the menu board. He's been standing in that line for 3 minutes, not talking to anyone, not on his phone, just waiting his turn to order coffee like everyone else. Normal Wednesday morning routine he's done hundreds of times before. Then a police officer enters the frame. What that officer doesn't know is that the man in line is Judge Marcus Thompson, United States District Court Judge for the Northern District of Illinois. He's presided over 3,000 federal cases in 15 years on the bench. He's written opinions cited by appellate courts 47 times. He understands the Fourth Amendment better than most law professors, and in approximately 11 minutes, this officer is going to handcuff him, detain him in front of everyone in this coffee shop, and trigger a lawsuit that will cost Chicago $7.5 million and create new training requirements for police departments across Illinois. Marcus Thompson is 56 years old, and he's been making criminals nervous from the bench since he was appointed to the federal judiciary at 41. He grew up on Chicago's West Side, son of a mechanic and a nurse, who emphasized education with the intensity of people who understood their sons' opportunities would be measured differently. Full scholarship to Northwestern, Harvard Law School, where he made law review. Moved 8 years as a federal prosecutor with an 87% conviction rate, major law firm, state circuit court judge. Then federal appointment at 41, lifetime position, one of the most powerful jobs in the American legal system. 15 years presiding over drug conspiracies, fraud cases, civil rights violations, police misconduct. Defense attorneys prepare harder for his courtroom because he reads every brief and catches every error. His written opinions are models of legal reasoning, clear and thorough, and nearly impossible to overturn on appeal. He's sentenced gang members to life and corrupt cops to federal prison. He's ruled on constitutional questions about search and seizure and due process and equal protection. He's also black, which most days doesn't matter in his courtroom, where the robe and the constitutional authority command respect. But outside the courthouse, in coffee shops and stores, and on streets, the robe doesn't protect him. People see him and make assumptions that have nothing to do with his actual identity. That Wednesday morning, Marcus is doing what he does every Wednesday morning, getting coffee at Martin's Coffee House, 3 blocks from the federal courthouse. He's been coming here since his appointment. The staff knows him. The owner knows him. He orders the same thing every time. Large dark roast, black blueberry scone, routine, boring, completely unremarkable. He arrives at 7:27 a.m., walks into the coffee shop. 8 people ahead of him in line. He stands there scrolling emails on his phone for 90 seconds. Mom then puts it away and looks at the menu board, even though he'll order the same thing he always does. 2 blocks away, Officer Brian Foster gets a dispatch call. Report of suspicious activity at Martin's Coffee House on Jackson Boulevard. Caller says there's a male acting suspiciously near the register. No specific threat, but caller requested police presence. Foster is 31, 6 years with Chicago PD. He responds that he's 2 minutes away. Doesn't ask what specifically makes the person suspicious. Doesn't ask if there's been threatening behavior. Just heads to the coffee shop. He arrives at 7:29 a.m., walks into Martin's, scans the interior, sees the line, sees Marcus standing there in his suit, sees a black man in a predominantly white crowd. Foster's brain, primed by dispatch about suspicious activity, he makes connections that have nothing to do with behavior and everything to do with bias. Foster approaches. Marcus doesn't notice until Foster is right there. "Sir, I need to see some identification now." Marcus looks up, confused. "Identification? I'm ordering coffee. What's the problem?" "We've received reports of suspicious activity in this area. I need to see ID, and I need to know what you're doing here." Marcus feels that familiar weight, the assumption, the suspicion, the demand to prove he belongs. "Suspicious activity? I'm standing in line at a coffee shop at 7:30 in the morning. What exactly is suspicious about that?" Foster's voice hardens. "Sir, I'm not going to ask again. Show me your ID, or you're being detained." Around them, people are noticing. Conversations stopping. Customers turning to watch, Marcus calculates. He can show his ID and probably be done in 30 seconds. Or he can stand his ground, force this officer to articulate reasonable suspicion, document what's happening. He's a federal judge. He knows the law. He knows this stop has no legal basis. And he's tired of proving he belongs in spaces where he has every right to be. Detained for ordering coffee? On what grounds? "What reasonable suspicion do you have that I've committed a crime?" Foster's hand moves toward his handcuffs. "You're being uncooperative. That's grounds enough. Hands behind your back." Marcus doesn't move. "You're arresting me? Let me be very clear about what's happening here. My name is Judge Marcus Thompson. I'm a federal judge for the Northern District of Illinois. I've been coming to this coffee shop for 6 years, and you're arresting me for standing in line. Because I'm black. Have you ever been somewhere you went every day and suddenly been treated like you didn't belong? Like you were a threat, for no reason except the obvious one? Drop a comment, because what happens next is going to cost Chicago $7.5 million. Most officers, when told they're about to arrest a federal judge, would pause, would verify, would call a supervisor. Foster doesn't pause. "I don't care who you say you are. You refuse to show ID. You're being detained for obstruction." Marcus pulls out his phone, starts recording. "Then detain me. Do it in front of all these witnesses. Because when this is over, the city is going to pay more for this coffee than you'll make in your entire career. And you're going to learn exactly what happens when you violate the constitutional rights of someone who spent 23 years interpreting the Constitution." Foster pulls out handcuffs. Real metal handcuffs. "Turn around. Hands behind your back." Marcus turns slowly. The handcuffs close around his wrists. Customers are pulling out phones. Recording. The barista, Sarah Chen, who's made Marcus's coffee 3 times a week for 6 years, watches with her mouth open. "Officer, that's Judge Thompson. He comes here all the time. He's not doing anything wrong." Foster ignores her, walks Marcus toward the door. The owner, Martin Rodriguez, comes from the back. "What's going on?" "Judge Thompson, what's happening?" Marcus keeps his voice level. "I'm being arrested for ordering coffee while black, Martin. He makes sure someone gets the security footage. I'm going to need it." Outside, Foster removes the handcuffs. "You're free to go. Next time, show your ID when asked." Marcus rubs his wrists. "Free to go after you handcuffed me in front of everyone I know, after you violated my Fourth Amendment rights." He pulls out a business card. Federal Judiciary seal. His name, his title. He hands it to Foster. "Give this to your supervisor, because you'll be hearing from me." Foster takes the card. His face changes as he realizes this was actually a federal judge. "Sir, Don't. You had opportunities to verify. You chose to handcuff me instead." Marcus walks back into the coffee shop, orders his coffee, sits for 10 minutes drinking it, hands shaking slightly, processing what happened. A federal judge, handcuffed in his regular coffee shop for standing in line. He walks to the courthouse, through security, where the marshals know him by name, up to his chambers. His clerk, Jennifer Martinez, sees his face. "Judge, you okay?" "I just got arrested at Martin's." "What?" Chicago PD officer walked in, demanded ID, handcuffed me when I asked what I did wrong. "Are you serious?" "Completely. And I'm about to make it expensive for the city." He calls David Kim, a civil rights attorney he's known for 20 years. When Marcus finishes explaining, David is quiet. "Marcus, you're a federal judge. This will be public, intense. You'll be a plaintiff in the federal system." "I've thought about it. This wasn't a mistake. This was a constitutional violation. If it happened to me, it's happening to others who don't have the resources to fight." "Then let's file." 3 days later, Marcus files a federal lawsuit. Thompson versus City of Chicago, Officer Brian Foster, Chicago Police Department, 73 pages. Filed in Northern District of Illinois, but transferred to Northern District of Indiana to avoid appearance of bias. Judge Sarah Morrison agrees to take it. The complaint alleges unlawful seizure, racial discrimination, false arrest, false imprisonment, intentional infliction of emotional distress, failure to train and supervise. Marcus asks for $7.5 million plus comprehensive reforms to stop and identify policies. Attached, security footage from Martin's showing the entire encounter, statements from 6 witnesses, Marcus's recording, and statistical analysis showing Chicago PD stop patterns. In 3 years, Chicago made 147,000 stops demanding ID from people not suspected of crimes. Black Chicagoans are 30% of the population, but 62% of those stops. The lawsuit becomes national news. Federal judge sues Chicago police after being handcuffed at coffee shop. The video gets 8 million views in 48 hours. People watch Marcus standing in line, Foster approaching, the conversation escalating, handcuffs, being walked out, all documented. Chicago PD issues a statement. "We take these allegations seriously. The incident is under internal review." The statement does nothing. Within 24 hours, #Justice for Judge Thompson trends with 89,000 tweets. The city reaches out about settlement 2 weeks later. They offer $500,000, Foster's termination, revised training. Marcus rejects it. "That's insulting. I want public accountability and systemic reform." They come back with $2 million in training. And Marcus says no. "Training means nothing without oversight and enforcement. I want data collection on every stop, quarterly review of patterns, early intervention when officers show disparities, independent civilian oversight, court-ordered so it can't be discontinued." 3 weeks of negotiation. The city argues court-ordered reforms interfere with operational independence. Marcus's attorney argues that operational independence led to a federal judge being handcuffed. The city comes back at $5 million with limited reforms. Marcus stands firm. Discovery begins. David Kim deposes Foster for 9 hours over 2 days. Foster tries to maintain he was responding appropriately to dispatch. "Officer Foster, when you arrived at Martin's, what specifically did you observe that was suspicious?" "Dispatch had reported suspicious activity." "What did you personally observe?" "People in line." "Which person did you identify as suspicious?" "The subject in the suit?" "Judge Thompson." "What was he doing that was suspicious?" "Standing near the register." "In line to order coffee?" "Yes." "What about standing in line is suspicious?" Foster has no answer. David continues. "When Judge Thompson asked what reasonable suspicion you had, what did you tell him?" "I told him he needed to show ID." "Did you articulate what crime you suspected?" "He was being uncooperative." "That's not a crime. What crime did you suspect that justified demanding identification?" "I don't need to suspect a specific crime to ask for ID." Under Terry versus Ohio and Illinois law, you do need reasonable suspicion. Did you have that? Foster doesn't answer. When Judge Thompson told you he was a federal judge, what did you think? I thought he was trying to avoid showing ID. Did you consider verifying? No. Why not? I had already committed to detaining him. You committed. So even after learning he might be a federal judge, you proceeded because you'd already decided. Yes. In the past year, approximately how many stops have you made demanding identification? Maybe 30. How many involved Black or Hispanic individuals? Maybe 20. 2/3 of your stops involve minorities despite Chicago being 1/3 white? That's who I encountered. Or who you decided to stop. David also deposes Catherine Walsh, who called 911. She's 47. Works across the street from Martin's. The deposition is uncomfortable immediately. Ms. Walsh, what prompted you to call 911? I saw a man acting suspiciously. What was he doing? Looking around a lot. At what? Just looking around before going into the coffee shop. Was he carrying anything? I don't remember. Running? No. Trying to hide? No. What made you think it was suspicious enough to call 911? He looked out of place. Out of place how? He just didn't look like he belonged in that area. Ms. Walsh, what made this person look like he didn't belong? I just had a feeling. David slides a document across. This is your 911 call history. You've called to report suspicious activity 7 times in 5 years. All 7 calls describe Black or Hispanic men as acting suspicious or looking out of place. Not one describes specific criminal behavior. Can you explain that pattern? Catherine starts crying. I don't think of myself as racist. I was trying to keep people safe. By calling police on people walking into coffee shops? Ms. Walsh, do you understand your call resulted in a federal judge being handcuffed in public? I didn't mean for that to happen. But it did happen, because you looked at a Black man walking into a coffee shop and decided something was wrong. 5 months before trial, the city requests mediation, 2-day session. Day 1, separate rooms. City opens at $5 million with training reforms. Marcus counters at $7.5 million with court-ordered reforms, including data collection, civilian oversight, quarterly review. Day 2. Everyone in one room. The Corporation Counsel speaks. Judge Thompson, we acknowledge this was wrong. We're prepared to compensate you substantially, but $7.5 million and court-ordered oversight is excessive. Marcus responds, excessive? What's excessive is being handcuffed in a coffee shop I've gone to hundreds of times. What's excessive is living in a city where police stop Black residents at twice their population rate. The money isn't the point. The oversight is. Without it, this happens again. The reforms I'm asking for are basic accountability, data collection so patterns are visible, civilian oversight for independent review, early intervention when officers show disparate patterns. These should already exist. The police superintendent objects. Court-ordered oversight restricts operational flexibility. Every stop should be subject to review, Marcus says. That's accountability. What happened to me wasn't a mistake. It was a predictable outcome of a system that allows officers to stop people based on feelings rather than facts. They break. The mediator works both rooms for 4 hours. At 5:30 p.m., they reconvene. City's final offer, $6.8 million. 3 years of court-ordered data collection. Independent review with quarterly reports to federal court. Early intervention for officers whose stops show racial disparities exceeding 2 to 1. Additional training. Personal liability insurance for officers. Marcus counters, I want 5 years of monitoring, not 3. Culture change takes time. And I want the threshold at 1.5 to 1, not 2 to 1. Black people in Chicago shouldn't be 50% more likely to get stopped before it triggers review. The city confers. We can do 5 years. We can't do 1.5 to 1. Marcus leans forward. If your officers are stopping black residents at 50% above population rate, those stops need review. That's the point. Make it 1.5 to 1 or we go to trial. The superintendent nods reluctantly. Agreed. Settlement finalized March 22nd. $7.5 million. Marcus donates $4 million to civil rights organizations. Keeps $3.5 million. I'm keeping part because what happened had real costs. Professional costs, emotional costs, being humiliated in front of people I see every day. The money acknowledges that. But the reforms matter more. The reforms. 5 years of court-ordered data collection on all stops demanding identification. Data includes race, stated reason, outcome, duration, independent civilian oversight board with authority to review stop data. Quarterly reports to federal court showing demographics and disparities. Early intervention for officers whose stops show 1.5 to 1 racial disparity. 3 consecutive quarters triggers retraining or reassignment. Mandatory training on reasonable suspicion, Fourth Amendment rights, implicit bias. Annual refreshers. Personal liability insurance for all officers. Body camera requirements for all stops. Footage retained 5 years. Marcus speaks at the press conference in his judicial robes. 6 months ago, I was handcuffed in a coffee shop for standing in line. The officer couldn't articulate what crime he suspected me of committing. He couldn't explain what made me look suspicious except I looked out of place. I'm a federal judge who's gone to that coffee shop for 6 years. The only thing out of place was his assumption I didn't belong. These reforms prevent that assumption from becoming detention. Data collection makes patterns visible. Civilian oversight creates accountability. Early intervention catches problems before they're systematic. Personal liability makes officers think twice. If these reforms work, maybe the next black man standing in line won't have to prove he has the right to be there. Within 4 months, 2 other Illinois cities adopt similar reforms. The Illinois Attorney General issues guidance recommending all municipalities implement stop data collection. Foster was terminated 2 weeks after settlement. Appeal denied after union reviewed depositions and footage. He works private security now. Catherine Walsh stopped calling 911 to report suspicious activity. No calls in 2 years. 1 year after settlement, first quarterly report released. Year 1, 48,000 stops, demanding ID black residents 52%. On down from 62%, Hispanic 26%, white 18%, still disproportionate but improving. 73 officers flagged for disparate patterns, 42 retrained, 31 reassigned. The oversight is working. Marcus still goes to Martin's every Wednesday, same order, same staff. But there's a different feeling. People recognize him not just as the regular customer, but as the judge who sued and won. 2 years after the incident, a young black man approaches Marcus in line. "Excuse me, are you Judge Thompson?" "Yes." "I wanted to thank you. I got stopped by Chicago PD last month. Officer demanded ID. I asked what reasonable suspicion he had. He couldn't articulate one. I filed a complaint. Civilian oversight reviewed it. Officer got flagged because it was his 4th stop in 3 months showing disparity. He's getting retrained. None of that happens without your lawsuit." "Did he give you trouble when you asked about reasonable suspicion?" "Yeah, said I was being uncooperative. But I knew my rights, I knew about your case." "Good. That's what the reforms are for." Marcus orders his coffee, sits at his usual table. Normal Wednesday morning, except it's only normal because he refused to accept that being handcuffed for ordering coffee was acceptable. What stays with me isn't the $7.5 million or Foster losing his job. It's Catherine Walsh calling 911 and saying Marcus looked out of place. 7 times in 5 years. 7 men of color. 0 specific behaviors. Just feelings. And every time she called, the system responded. Sent officers. Demanded ID. Created confrontations where none needed to exist. The system was designed to validate her feelings without questioning merit. The reforms address that. Officers must articulate reasonable suspicion before demanding ID. Data collection makes patterns visible. Civilian oversight reviews whether stops are justified. Early intervention catches officers who repeatedly stop people without cause. But the reforms can't fix Catherine's instinct to be uncomfortable. Can't eliminate bias that made her see Marcus and think suspicious instead of person getting coffee. What reforms can do is create checkpoints that force officers to articulate facts instead of validating feelings. Make it harder for someone's discomfort to become someone else's detention. Marcus had every advantage: federal judgeship, legal expertise, resources, platform. And he still got handcuffed because an officer saw threat instead of judge. This story ended with reforms because Marcus sued instead of settling quietly. Most people who experience this don't have those advantages. They get stopped, maybe file complaints that go nowhere, move on. The system doesn't change. It changed because a federal judge forced accountability. The reforms improve odds for everyone. Don't eliminate bias. Don't guarantee justice. Just create more oversight before feelings become detentions. Make patterns visible. Create accountability. Add consequences. That's incremental progress. Not perfect. Not complete. Just measurably better than before. Marcus stood in line at Martin's and Foster decided he looked suspicious. And share this if you think police should articulate reasonable suspicion before demanding ID instead of responding to feelings. Catherine Walsh called 7 times about men of color doing nothing wrong. 7 confrontations that didn't need to happen. It took a federal judge being handcuffed for the system to ask, should we be doing this? The footage is still online. 7 million views. People watch Marcus standing in line, doing nothing, getting handcuffed anyway. And maybe they ask, if this happens to a federal judge, what's happening to everyone else? That question is what reforms answer. Through data, through oversight, through accountability. Because feelings aren't facts. Discomfort isn't suspicion. And someone looking out of place says more about the person looking than the person they're looking at. The coffee shop is the same. The routine is the same, but the system is different. Slightly, measurably better. Progress measured in data points and oversight mechanisms and quarterly reports. Measured by a young man who knows he can ask for reasonable suspicion and file complaints that get reviewed. That's what $7.5 million and 5 years of court monitoring bought. Not perfection, just accountability. And in a system that had none, that matters.